Hello guys, and welcome to another episode of my lecture. On today's episode, we will be discussing about oral evidence. In my previous lectures, I discussed about fact and factination, and I told you that in this class, we will be discussing oral evidence. Now, what exactly is oral evidence? Oral evidence is the totality of speech that a witness gives in the witness box. Do you understand? Let us take it step by step, but let us start with that. When you are talking about the speech given by the witness in the witness box, you know that where there is a lawsuit, like I said, the fountainhead of law is what? Facts. You need to adduce facts before the court. Now, when you are adducing facts, you can either adduce a document as evidence or you adduce oral testimony of witnesses. Do you understand? Now, when you are adducing oral testimony, you bring a witness into the witness box to come and speak as to what he or she knows on a particular matter. Do you understand? So, when you are talking about oral testimony, in the case of Biliaminu Bello and Miriam Sanders that have been using as, an example, you would see that Ibrahim Mohammed, Biliaminu's friend, who was at the house, as at the time she was angry, she charged the team, removed knives and all those things. Ibrahim Mohammed came to the witness box to testify as to what he saw. Oral accounts of what he saw. That is oral evidence. Another thing you should know about oral evidence is that there is something known as examination in chief, cross-examination, and re-examination of witnesses. Now, if it is the prosecution that is bringing a witness, when the witness enters the witness box and begins to talk, the prosecution is not allowed to lead the witness on what to say. Do you understand? The prosecution is supposed to ask normal questions while the witness answers. Normal questions which are open-ended and not closed. So, for example, if I were the prosecution lawyer and Ibrahim Mohammed is in the witness box, my question to him would be, where were you on the 29th of September 2017? It tells me where he was. So what happened next? What happened next? What happened next? But if I ask a question like, were you at Biliaminu's house on the 29th of September? That is a leading question, because then I want him to tell me yes or no. Do you understand? But instead of that, you ask proper questions that would let him speak as to where he was, not you lead him to telling us where he was. Now, after that, you have cross-examination, where the other party comes to cross-examine the witness. The essence of cross-examination is to shake the credibility of the witness, to make him say something else, so that the court will not rely on his testimony. But if he is a credible witness, in my next subsequent set of classes, I will teach you what a credible witness is. But if he's a credible witness and the other party wasn't able to shake him during cross-examination, then so be it. The court is going to listen to what he says and attach weight to it. And then after that, you have re-examination, where the prosecution comes again to enlighten us, ask questions that must have been asked in examination in chief or cross-examination, which then becomes ambiguous. So the essence of re-examination is to clear the ambiguity that must have arisen during cross-examination or examination in chief. Do you understand that? So basically, we are talking about oral testimony. When the witness enters the witness box, it gives us an oral account of what he knows about a particular thing. Do you understand? So let us look at section 125 of the Evidence Act. It says that all facts except the content of documents may be proved by oral evidence. All facts except the content of a document may be proved by oral evidence. I see, I saw, I heard, I this, I that. You can prove it by oral evidence. Don't forget that when we are talking about facts, you already know what a fact is. Anything, state of things, relation of things that can be perceived by the five senses. So all facts that can be perceived by the five senses can be proved by oral evidence except a document. That's the content of the document. You can prove the existence of the document by oral evidence, but you cannot prove the content by oral evidence. Do you understand that? And also, when we are talking about physically impaired people, whatever sign language they give would also be regarded as oral evidence. Let us go to section 176 of the Evidence Act, where it tells us that sign or body language demonstrated by an incapacitated person while in the witness box testifying would also be known as oral evidence. So with that, you understand what oral evidence is, where you bring a witness to come into the witness box to tell us things, tell us facts as to what he knows, what he saw, what he heard, what he felt about a particular matter, and then that kind of evidence is admissible as oral evidence under section 126 and section 176 of the Evidence Act. In my next lecture, I will be discussing about documentary evidence. Now that we know a little about oral evidence, why not let's find out what exactly is documentary evidence. See you in my next class.